try to cover in about an hour before we move on to the more technical skills of what the pre-trial hearing is to talk about understanding what a pre-trial hearing is, the difference between a pre-trial hearing and the actual trial, because they serve different purposes, and it's really important that we all understand that and have that common understanding. And really to understand the importance of a pretrial hearing to the process, to promote justice and fairness, and really allow people to have access to a fair trial, and to make sure evidence that maybe is not properly obtained is not used against them. It's really a fundamental right. So we're going to start by talking about this. Training is about and what you will be doing and the skills you will be learning. They're applicable to a trial and to a pretrial hearing. But what we're really focused on is the importance of a pretrial hearing and not really a mock trial itself. So you may ask, what is the difference? I mean, I think we all know what a trial is. And in the criminal context, which is what we have in our case packet, the trial is where the court will determine whether the prosecution has proved whether the defendant is guilty. That's what the trial is about. But what we're going to be talking about today, and what you're going to be training about, and what the regional event is about, is a pre-trial hearing, and it's different. A pre-trial hearing is a court proceeding where the court decides if the evidence that is being used against the defendant, if it's fair to use that evidence, and if it should be allowed to be able to be used in trial. And usually that happens, almost always it happens, at least in my jurisdiction where I am in the United States, that's something that happens before the trial. And it can seem a bit like a trial because there may be witnesses and documents, but it's looking at the evidence and not looking at the guilt of the defendant or whether the prosecution proved their case. So it's an important distinction that it's important for all of us to understand and for you to understand, because you'll be working on opening statements and closing statements and examining witnesses over the next couple days. So it's important to understand that, so we focus on what the key issues are. So I'm gonna start this by just kind of trying to illustrate the importance of why a pretrial hearing could be important by giving you a set of facts, and then I'm going to ask you a question about it. So listen to this fact pattern. It's short, but then I'm going to do a poll and ask you a question about the evidence that I'm going to be talking about now. So I assume that I'm driving my car. I'm driving down the street, and a police officer pulls me over in my car randomly, just decides I'm going to pull Andrew over to see what's going on in his car. So I get pulled over. That police officer does not have any reason to believe I'm involved in any criminal or illegal activity. I'm not speeding. I'm not driving in a bad way. That officer just decides to pull me over. And in the course of that, the police officer then decides that he wants to search my car. And he opens my trunk. And in my trunk, he finds a bag, a backpack. That backpack has a tag on it, and that tag says, "This backpack belongs to Andrew." So it's pretty clear that it's my backpack. The police officer then opens the bag and finds a big, large bag of illegal drugs, cocaine. Again, it's in the backpack. The backpack's got my name on it. So you know, it's pretty clear that those drugs came from my backpack. So Matthew, if you could put up poll question number 1. Okay, well, good. Thank you all for sharing. So one of the things we're going to be talking about throughout the next 2 days, and this will play into the fact scenario of the packet that is part of the mock trial event, is you know, understanding, you know, when evidence is lawfully obtained from, you know, by the police, and when it is not. In my country, in the United States, the police cannot just pull someone over for no reason and search their car. So in my country, if the scenario that I had happened and the police just pulled me over and searched my car and found something, I would have a good argument that the prosecution would not be able to use that against me, because they did not have an adequate reason to pull me over in the first place. That's, you know, can differ in different countries, but it really goes to the idea that we want the police to be there to, you know, to protect us, not to trick us, and not to use their authority in a way that should not be used. So, so it will be interesting, maybe at the end of the 2 days, when we've gone through our facts scenario and we've been through some more of this, to see how people feel about that question, to see if they've changed their mind, or if they still think it's the same. So kind of keeping with that scenario, if I were to challenge, if I wanted to challenge the prosecution, if I were arrested and there was going to be a trial of me for possession of those drugs, instead of waiting for the hearing, I could try to have a pretrial hearing to exclude that evidence from the trial. And the importance of that is that if I were able to exclude the evidence before trial, then the prosecution really would not have a case to bring against me. So again, a pretrial motion or a pretrial hearing is really just, it's an application to the court to hear an argument about an issue before the trial commences. And in this case, specifically, what we're going to be talking about over the next couple days, it's a pretrial motion to exclude evidence before it would be used in the trial. And there's many legal reasons to do that, but the ability to file a pretrial motion and have the court hear this before trial is really a core part of ensuring that there's a fair trial, that evidence that should not be brought to trial is excluded. And it goes to the rule of law and to making sure that those who are arrested are not unjustly convicted. But again, the pre-trial hearing is not the trial itself. It's something that happens before the trial, but it can look very similar to a trial. In a pre-trial hearing, as you'll be learning throughout this training, there can be opening statements, there can be an examination of witnesses, there will be documents entered into evidence. So it's almost like a mini trial, but the issue that's being looked at is the admissibility of evidence, not the guilt of the defendant. And so this case packet that I think you've all received includes a motion to exclude evidence that was filed by the defense advocate in this case, which is the Zoltanu versus Eltra Parker case. So I hope everyone has had an opportunity to review the packet in advance and have looked at that. I think we're going to break up. We're going to probably spend just 5 minutes in these smaller groups and introduce yourselves to each other and have a conversation in your group about what you think about the idea of having a pretrial hearing, and especially as it relates to the exclusion of evidence, why that's important to the defendant, why that's important to the legal system as a whole, to society. And then we're going to come back as a big group. We'd like to hear from a few of you on this topic, because it's important that we talk them through and hear each other's opinions on these things. So when you're in your group, maybe we won't get to every group probably, but pick a spokesperson who can come back and share with us for maybe 1 or 2 minutes. Well, this was great, and we're going to be doing a lot more of this type of breakout and discussion over the next couple days, and we encourage you all to continue to participate and volunteer in that respect. I mean, I really liked a lot of the comments I heard from the discussion on this topic. You know, here are some of them. You know, it ensures a fair trial if you can have a pretrial hearing where evidence is reviewed. It places, it's a place for the defendant to speak up for his rights. It helps alleviate misuse of power. A pretrial hearing leads to a fair trial. I like that. The legality of collective evidence, it stops coercion. I think those are all really important. That's what we were trying to get at. Really important policy, societal justice issues in terms of why this is important. So we spent a lot of time crafting this particular case scenario because we want you to be thinking about these types of issues. The skills you will learn over the next 2 days are important. How to come up with a case theory, how to give an opening statement, how to examine a witness. But as important as that, and probably even more important, we want you to be starting to think about the fairness of the system and how to be thinking about making sure it's your job when you become lawyers to make sure not only that you're representing your clients, but that the system is operating fairly, and thinking about if your system is not perfect now, that there are ways to try to change that in the future so that there's more fairness and that people's rights are not overlooked. Because, you know, sometimes even if someone is guilty of a crime, if that evidence of that was obtained illegally, then sometimes it's better that that person, you know, not be found guilty because they were not properly, the evidence was not properly obtained. And if that's the case, then the police act more honorably, and you know, the courts will enforce the rules in a better way. So those are the things we want to make sure you're thinking about as you study this case scenario and as you are working through this over the next couple days, but also throughout your careers. So I think I want to just move on. There's a couple other topics I want to hit while we have a little bit of time. And one of them has to do with the burden of proof. Okay, so if people could go, do people understand, and you probably studied it in law school, but what the burden of proof means? The burden of proof is who has the burden of establishing the case in a trial. So, for example, in a criminal trial, is it the prosecution who has to prove that the defendant is guilty, or is it the defendant who has to prove that the prosecution hasn't established their case? So the plaintiff in a civil case or the prosecution in a criminal case has the burden of proof. And in this fact scenario, we're talking about a criminal case. So I want to talk about that. There's a difference, and this is in your packet as well. So when you review it, make sure you focus on this. There's a difference between the burden of proof at trial and the burden of proof at a pretrial hearing. Certainly for purposes of this exercise, there is. And at the trial, the burden of proof is a big burden. It's a huge burden for the prosecution, and it's called beyond a reasonable doubt. So beyond a reasonable doubt is big. That means like the evidence is almost overwhelmingly strong against the defendant. So when you think about it, it's like, if you have all the evidence, you're holding it all up. It's so much evidence, heavy evidence.
Can everybody do this? Everybody turn your camera.
Everybody,
push up.
Hands up.
You're pushing something really heavy above your head. It's heavy.
Beyond a reasonable doubt.
Let's see everybody lifting that. Okay, above your heads. Everybody, hands above your heads.
Big
above
evidence.
Your heads. Okay.
So if there's reasonable doubt, even if it's small, the prosecution has not proved their case. Big evidence. For a pretrial hearing, it's still the prosecution's burden to show that evidence is relevant and should come into trial, but it does not need to show it by beyond a reasonable doubt. It shows it by something called a preponderance of the evidence, which is more like this, like 51% to 49%, like 50-50 almost. So just if it can prove, more likely than not that the evidence is relevant, then that evidence is going to come in. So everyone do this. This is preponderance of the evidence.
Or Andrew,
50,
we also call it a balance of probabilities.
Okay, balance of probabilities.
Preponderance of the evidence. The same term, same idea.
Okay. So great. We've got, what do we have? A couple more minutes. So I'm just going to share screen with you again for a moment. Just to kind of put into context what we've talked about here. So again, the exercise we're doing for purposes of this mock pre-hearing is the pre-trial hearing. So what you need to remember is right here on this side of on the pre-trial side of the screen. One, it's before trial, so we talked about that. The issue is the admissibility of evidence, and that's the only issue that's going to be relevant. Was the evidence obtained and kept legally, and should the prosecution be able to do it? Trial is different. Trial, we're talking about guilt. Again, beyond a reasonable doubt, did Eltra Parker possess drug? Did she act with intent? Was the arrest legal? That's trial. That's not what this is about. This pretrial hearing is about was it admissible, and should it be used at trial? And that's what, when you're working on your opening and closing statements and your witness outlines over the course of the next couple days, keep coming back to that. It's about admissibility. And so I'm just going to close with one final slide, if I can. I got to stop my annotations first. Hold on. So in the case that you got the packet for, which is where we're going to pick up over the next several sessions, there's a motion to exclude evidence, and it will be heard in a pretrial hearing. And if you haven't looked at it already, you have a break right now. The motion to exclude is on pages 20 and 21 of the packet you were sent. It's called Motion to Exclude Evidence. It looks, well, see if I can get it. It looks like this. I marked mine with the tag. You're going to be using this a lot over the course of the next couple days. So make sure you go look at this, because this is the operative motion, and this is the evidence that you're going to be arguing should be excluded from trial. And it's three basic things. To exclude evidence, that statements that Eltra Parker made after she requested an attorney, that those should be excluded. That testimony related to statements made during an interview should be excluded because it was overheard by a jail officer. And to exclude some evidence that was seized from the vehicle because there was not a proper chain of custody. The drugs were not properly cared for by the police. So those are the three things that you're going to be focusing on as you prepare and work through this case scenario. So again, I encourage you to look at those closely, because those are the things you want to frame your arguments about. Don't say at the end of your opening statement, so the defendant is guilty, because that's not what is being done here. That's for the trial. What you'll be saying is, this evidence should be excluded from trial. And if this evidence is excluded from trial, you will have done your client a service, because if the prosecution does not have evidence, the prosecution will not prevail. So thank you very much. This
and
has
of course,
been
just to jump in, if you're the prosecution, you're going to say the opposite. You're going to say, Judge, this evidence was obtained legally, fairly, and kept. And this evidence, therefore, for a fair trial, should be used in the prosecution to ensure a fair trial. So you're going to—
Thank you, Bruce.
Yeah, you
exactly.
say it both ways.
Yeah, that's exactly right. And we hope over the course of the next 2 days, because there's various exercises, you will be able to play both sides. You'll play the prosecution side for some things and the defense side for some others, because it's important to be thinking both ways. That actually helps you become a better lawyer when you start thinking like the other side. So that's the end of our time. We're going to take our break. I'll turn it back over to the Babsicle team to tell you what to do next, if anything, other than take a break and come back in a few minutes.